So the suppressor freedom lawsuit, which aims to remove a state ban on the purchase and possession of suppressors, is now facing being thrown out. So let's talk about this. But real quick before we jump into this video, if you think bans on suppressors is clearly unconstitutional, go ahead and hit that like button and subscribe. Also, I want to mention that we have an event coming up. It's the Route 66 Range Expo. It's coming up this weekend, October 7th through 8th. I'll be there. Mike Glover will be there. Reno May will be there. A ton of vendors. It's always a great time. So if you guys are interested, you can pre-register for the event using the link down below in the description section, and then also the pinned comment. So as I mentioned in the intro, in this video, we're going to be discussing two lawsuits which aim to remove a state ban on the purchase and possession of suppressors. The cases we're going to be talking about in this video are Morse v. Raoul and then also Anderson v. Raoul. These two lawsuits are filed in a federal district court in Illinois, and they aim to remove the state of Illinois' ban on the purchase and possession of suppressors. These lawsuits are important because although 42 states allow for the ownership of suppressors, there are 9 jurisdictions within the US which do not. These lawsuits could be the first in the nation which find that a state's outright ban on NFA items like suppressors is in fact unconstitutional and violates the Second Amendment. However, in this case, the state of Illinois is trying to have the case completely thrown out by arguing that suppressors are not arms and therefore they are not protected by the Second Amendment at all. Therefore, the state of Illinois is requesting that the judge in this case grant them a judgment on the pleadings and just issue it in their favor and throw this case out right here and now. This lawsuit aims to finally make a state like Illinois explain how their outright ban on the purchase and possession of suppressors is consistent with both Heller and Bruin. Both of the plaintiffs in these lawsuits argue that suppressors are clearly arms protected by the text of the Second Amendment, and also that they are not dangerous and unusual. Instead, these are common arms but owned by law-abiding people for lawful purposes. But now the state of Illinois has filed a motion for judgment on the pleadings. Now, for those not aware, a motion for judgment on the pleadings is a motion made under Federal Rules of Civil Procedure, Rule 12C. It is used to attack the sufficiency of an opponent's pleadings and the viability of their underlying claims prior to a trial taking place. The court, in reviewing the motion, is strictly limited to the contents of the parties' pleadings, so essentially what they pled, the complaint, and then any documents that were attached to that. If the party wins the motion, then the claims are dismissed by the court and often can prevent a new lawsuit on the same claims from being brought, in the future. So it's something that would be critical and would foreclose any future challenges if the state wins this. So the state of Illinois is trying to get this suppressor lawsuit thrown out and also prevent any future challenges. Now, in their motion, Illinois argues that plaintiffs raised a Second Amendment challenge to an Illinois law prohibiting the possession of silencers, which are attached to firearms, to reduce the noise of gunfire. But the Second Amendment protects only the right of the people to keep and bear arms. Silencers are not weapons. They are not used for self-defense, and they are not necessary to the effective use of a firearm. So they are not arms within the meaning of the constitutional text, and thus plaintiffs cannot prevail on their Second Amendment claim. They go on to argue that plaintiffs wish to possess silencers. So the question is, does the Second Amendment cover this conduct? Or more particularly, are silencers arms within the meaning of the constitutional text? Every court to address this question has held silencers are not arms protected by the Second Amendment. They go on to state that silencers do not satisfy the definition of arms. A silencer is a firearms accessory. It is not a weapon in itself, nor is it an armor of defense. So the state's primary argument is that suppressors cannot be considered an arm under the Second Amendment because it is not an actual firearm, it's not an actual weapon that shoots a projectile. They claim that only actual firearms can be considered arms and therefore protected. They believe a suppressor is simply an accessory that cannot be protected. They then argue that a suppressor cannot be protected by the Second Amendment as an arm because they believe it is not necessary for the function of a firearm and because it's not useful for self-defense. Now, in response to those absurd arguments, the plaintiffs argue in their response that the state's terse interpretation of the Second Amendment runs contrary to existing precedent and how constitutional rights are typically interpreted. First, suppressors are firearms because Congress said they are. Second, suppressors are protected arms because they facilitate armed self-defense. However, even if this court finds otherwise, suppressors are nonetheless protected by the Second Amendment because they are firearms accessories. And firearms accessories that assist with self-defense and other protected conduct are protected by the Second Amendment. As such, defendant's motion for judgment on the pleadings is not well taken and should be denied. They go on to say that the plaintiffs argue that the threshold textual inquiry does not ask what is necessary for self-defense. It asks whether a bearable instrument facilitates armed self-defense. The National Firearms Act defines firearm to include silencers, and the Gun Control Act likewise defines firearm to be any firearm muffler or firearm silencer. Under these statutes, silencers are per se arms, and this court must apply the statutory definition of silencer to be a firearm because when a statute includes an explicit definition, we must follow that definition even if it varies from a term's ordinary meaning. They go on to argue that suppressors are an important part of a firearm because they also help to mitigate some negative externalities and the potential of cause loud gunfire, and also helps to reduce some of the noise pollution and protect your hearing. The plaintiffs also go on to point out the fact that a rifle like an AR-15 or a handgun also have magazines and they can't be fired without one. And under the state's current logic that they're using in this case, that means that magazines are also not protected. This is the type of argument that California tried to also make in the Duncan California magazine ban case, which was also just recently rejected by Judge Benitez. Now, in response, the state has filed their reply supporting their position and the request for a judgment on the pleadings. First, the state argues that despite what Congress says in the GCA and the NFA about silencers being actual firearms, that doesn't change the intent of the Second Amendment and what the text says. To this end, the state is almost arguing that the federal statutory language about suppressors and silencers should almost be completely disregarded, and it doesn't matter what the NFA or GCA says. In some ways, they're almost advocating for maybe that the NFA and GCA is incorrect on whether a silencer or whether a suppressor is actually a firearm. They go on to state that, to be sure, the Morse plaintiffs suggest Congress has the power to change the meaning of the constitutional text by mere legislation. But long ago, Chief Justice Marshall rejected the notion that the legislator may alter the Constitution by any ordinary act. That puts an end to this argument. To me, this is almost an attempt by the state to have their cake and eat it too. I doubt they would say that the federal government cannot enforce the NFA and GCA's language about suppressors, but here they're saying essentially the court should just simply disregard it. The state goes on to argue in the reply that nothing in Heller or Bruin hints at extending constitutional protection to every object that makes a firearm marginally more pleasant to operate. They take the position that silencers are not necessary to the use of arms for self-defense, thus the constitutionally protected right is not infringed by their prohibition. It follows that silencers are not covered by the Second Amendment, they argued. The state's primary position is that since you don't need a silencer to fire or function a firearm, then it's not necessary for self-defense. They believe that only components of a firearm that are necessary cannot be banned, and all those accessories and components must be tied in some way to self-defense and be necessary for self-defense. Finally, the state then goes on to argue and tell the court that the current assault weapon ban and the magazine ban in Illinois is being reviewed by the 7th Circuit, and the 7th Circuit is supposed to issue a decision sometime soon. And so they believe that those restrictions on magazines, similar to the arguments that were made in California, may impact and implicate some of the things going on in this case. So they argue that the court potentially here maybe should wait for that decision, or they're actually saying that they would offer that as additional evidence to this court about why suppressors are also not protected like magazines. So these are really interesting positions that the state of Illinois is taking about suppressors. They're trying to get this case thrown out by taking the position that suppressors are not arms and therefore not protected by the text of the Second Amendment. I would say the NFA and those laws which directly contradict what the state is saying would be sufficient enough to at least beat this motion of judgment on the pleadings. But the state wants this court to completely disregard those federal laws, and it's going to be interesting to see what the court does with that. So this is something we'll definitely be keeping our eyes on going forward. But if I get any more information, I will definitely let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. If you want to support the channel, one of the best ways and the freest way to do that is simply liking, commenting, and subscribing. Especially subscribing, make sure you double check that you're still subscribed. A lot of people write comments that they've been unsubscribed. And when you do subscribe to the channel, make sure you click the notification bell next to it and click on all notifications, because that helps to actually get this information to you. And YouTube is supposed to send it out to you if you have all notifications on. And so that's another way you can make sure you're seeing these videos. I know about like half of my audience that are subscribed, actually it's more than that, do not have notifications on. So if you're missing these videos, that's probably why, because you don't have notifications on. But regardless, thank you guys so much for all of your support. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.